And I'd like to introduce Ellen Effers, who will introduce our speaker and our session for today.
Sharon Rush, who's our presenter today, also presented last year. And she is a distinguished scholar and a law professor emeritus from the Raymond College of Law. And her subject matter doesn't necessarily focus on a particular case, but what she addresses is the issues and the theories that the court uses, not just the Supreme Court, but all courts should be using when they decide cases and the interrelationship between those different theories and issues. And today she's going to talk about constitutional design, as you can see from the first slide of her PowerPoint, and the relationships that form the basis for the judge's decision. So with that introduction, I'd like to turn the presentation over to Sharon.
Thank you. It's wonderful to be back. I want to thank Ellen for inviting me to participate in this really exciting intellectual exchange that you all have going on with respect to the Supreme Court. I wasn't able to listen to John's presentation a few weeks ago. I had a prior commitment, but I did listen to it. Julie sent it to me and I was able to listen to it before today. And then I enjoyed very much Ken's presentation last week. So hopefully what I'm about to do today, I'm not focusing specifically on a case that's before the Supreme Court, but some of the cases that are before the Supreme Court fit into this, what I'm calling relationships by constitutional design. And it really is relationships by the Supreme Court's interpretation of the 14th Amendment constitutional design. So hopefully this will bring some perspective, inspire some insights. I would love to hear your comments and suggestions and so forth. So I'm looking forward to the end of this so that we can get into a discussion. My primary focus then is on the individual's relationship with the state. And to the extent that there's time, and I hope there will be, I want to talk a little bit about the role of Congress. And then of course, overarching role of the Supreme Court in all of this. I mean, this is the Supreme Court's design. So my goals are pretty modest, although we're going to be covering a lot of conceptual information, if you will. We're going to talk a little bit, learn a little bit of knowledge about what individuals are. I'm sure that you're all familiar with those, but I'll try to put them into this bigger picture. And then the primary focus is going to be to try to help you understand, for those of you who haven't studied law or studied this in your studies, how the court evaluates whether a law is constitutional when a state passes a law. And then again, hopefully we'll be able to learn about the role of Congress in all of this. So part one then is going to focus on the individual and the state, and then part two will focus on the role of Congress in all of this. But over all of this is the Supreme Court. This is the Supreme Court talking to us, if you will. So the individual's relationship with the state begins with the 14th Amendment. And I've put section 1 up there in case you're not familiar with it, or to remind you what it says. The parts we're going to be focusing on are in yellow and underlined. So no state, okay, shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So we're going to be focusing on three things: state action, and then the due process clause, which is about rights, and then the equal protection clause, which is about people. Okay, I want to kind of remind us, although I'm sure that you're very aware of this, that in a democracy, most of the time the majority wins. You know, like, where are we going to go eat dinner? Well, let's take a vote. Where shall we go? And the majority wins. But sometimes in our democracy, especially, the individual wins, and is able to overcome whatever the majority would otherwise impose on the individual. Okay. So with respect to state action, and I know John Mills talked about this because this is relevant to what's going on with the Texas abortion law, but only the state can violate your constitutional rights. Private people cannot violate our free speech rights, for example. Yes, private people can commit crimes against us, they can commit torts and so forth, and that's a whole different thing. When we talk about the 14th Amendment, we have to have state action in order for the 14th Amendment to apply. And when we talk about state action, that can be at the state level or any level below the state, the county, the city, the municipality, or whatever. Okay. So before the 14th Amendment even kicks in, I've got to have state action. Okay. The state can violate our rights in one of two ways. Okay. It can enact an unconstitutional law, which is what we're going to be focusing on, or of course, a state employee at whatever level. Again, county, municipality, city, or whatever, they're all state employees, okay, for purposes of the 14th Amendment. When state employees are on the job, when I am in the classroom at the University of Florida, I am a state actor, I am held to constitutional standards. Okay, but that is a whole different lesson. That's not what we're talking about today. We're talking about laws then. Okay. So my screen just froze up, Julie. I don't know why. Oh, maybe I don't know why it just froze up. Oh, there. Okay, so let's focus then on due process. Just by way of introduction, I want to say that due process protects fundamental rights. Okay, and equal protection protects our right to be treated equally by the government. Okay, we're going to talk about them separately, due process and equal protection, but it's very important to keep them separate. So due process, I'm constantly saying to my students, rights are rights and people are people. And due process and equal protection are independently significant in law. So take a concept like gay marriage. Okay, there is no such thing as gay marriage in law. Okay, we all understand what we mean by gay marriage, right? We all get it. We all understand what it means, the Latina vote, for example, but there is no such thing as gay marriage, Latina vote. Okay, with gay marriage, for example, marriage is the right. That's governed by due process. And then who can marry? That's a question of equal protection. Same-sex couples, different sex couples, interracial couples, that's equal protection. Okay, so rights are rights, that's due process, and people are people, and that's equal protection. And you'll see why I harp on this when we get towards the end of this, because it's very important not to collapse those two independent clauses in the Constitution. Okay. So we're talking about the individual's relationship with the state. It's governed by the 14th Amendment, needs state action. Sometimes the majority wins in a democracy, but sometimes the individual wins. Okay, and as you all know, we're kind of in a heightened era that really started, I think, in the 1990s with the Rehnquist Court. We're in a heightened era of states' rights. So it's almost like this overpowering, if you will, idea that states should dominate almost everything, if you will. So due process protects rights and equal protection protects people. So let's focus on rights then. Just to be clear, because someone might have this, want this clarified as we go through it, there are two types of due process. There's procedural due process and there's substantive due process. We're going to be focusing on substantive due process. Procedural due process is the government having an obligation, a constitutional duty, if you will, to give you notice and an opportunity to be heard. Okay, so the social worker calls you up and says, hey, I'm going to take your kids away from you. We're going to have a hearing down at the courthouse at such and such a time. Come and be heard. Okay, that's procedural due process. But substantive due process is, whoa, wait, why are you taking my kids away from me? How do you justify taking my kids away from me? You can give me all the procedural due process not violate my procedural due process, but it has nothing to do with how the state has to justify why it's doing to us what it's doing. So substantive due process is a lot more controversial than procedural due process, and they're very different. Okay, we're focusing then on substantive due process. So when we think about individual liberties and under the due process clause, those fundamental rights come from the Bill of Rights, which I just abbreviate BOR, and then implied rights. Okay, and that's what we're talking about when we talk about substantive due process. Just to be clear as we go through this, both the federal and state governments have to respect these rights and cannot violate them. Okay, we're simply focusing on the state, but my students are surprised to learn that in the beginning, the Supreme Court said that the Bill of Rights, freedom of religion, all those important rights, only limit the federal government. States weren't obligated to abide by the Bill of Rights in the beginning because it was thought that you couldn't trust the federal government, but you could trust your state government. And then, of course, the Civil War flipped that trust relationship, so that following the Civil War and adoption of the 14th Amendment, okay, states couldn't be trusted to protect the rights of the newly freed slaves. So the court started incorporating or applying the Bill of Rights to the states. And this is what you'll hear in law called the incorporation doctrine. And how is it doing that? Well, it takes that word liberty in the due process clause of the 14th Amendment, okay, and it says liberty means free speech, freedom of religion, right? So it interprets that word liberty, okay, to protect individuals' Bill of rights and those implied fundamental rights from state, just like they apply properly, okay, against the federal government. And it applies at all levels of the government. The legislative, executive, and the judicial branches are all held to these standards. Okay, of course, we're focusing on state laws. Okay, so given that then, okay, almost every reasonable person has some idea in their hearts and minds that some rights are more important than other rights. And in law, those really important rights we call fundamental rights. Why are they fundamental? Well, because they're part of our liberty that's protected by the 14th Amendment. Okay, there's that word. No state shall deprive anyone of liberty without due process. Okay, it's the Bill of Rights. Most of them, not all of them have been incorporated, but that's okay. And then implied rights. Those Bill of Rights that have been incorporated, the big ones, I'm sure you're familiar with them: free speech, freedom of religion, right to bear arms. That's pretty new. Fourth Amendment right to be free from unreasonable searches and seizures, right not to incriminate yourself, right to counsel, right to be free from cruel and unusual punishment. Those are big rights. Those are really, really important in our democracy. And so, yes, the federal government has always had to abide by those and protect those. But through the incorporation doctrine, over decades, the court said, well, states, you have to protect these rights as well. And then, of course, there's those implied rights. This is where the court really gets criticized sometimes for stepping outside of its role in our constitutional design by reading into the word liberty, not just those rights that are in the Bill of Rights, okay, but some that aren't even there, right, that are implied in the Bill of Rights, like privacy, like marriage. Okay, those are implied fundamental rights, but they are fundamental rights. And only because the court says so. Okay, so if a right isn't fundamental, an FR right, then I call it an OR right, just an ordinary right. It's less important, but by saying that, I don't mean to suggest it's not important. It is important. All of our rights are important, but fundamental rights are more important than other rights. Okay, so I just delineate them, okay, into fundamental rights and ordinary rights. Given that then, okay, we have to think to ourselves, okay, so a state enacts a law then that burdens a right. How do we, okay, decide whether the law is constitutional? And I cannot highlight enough that this analysis comes from the court's interpretation of the 14th Amendment, okay, and other parts of the Constitution. Well, I do have some good news. At least I keep reminding myself this is good news when I think about what's going on in the world today. At a minimum, okay, our legislatures have to pass rational laws. Isn't that good news? I think that's good news. So at a minimum, okay, in order to be constitutional, any law that the legislative body passes has to be rational. And we call this rational basis review. And all that means is that the law must be rationally related to a legitimate state interest. And it's presumed constitutional. Strong presumption of constitutionality. Okay, what are those legitimate state interests? Health, safety, and general welfare. Okay. So I thought I would give you an example just for fun of an irrational law because it has happened. It has happened that a legislative body passed an irrational law, meaning it was unconstitutional. It's not irrational, it's unconstitutional, right? So in this particular case, the state passed a law that limited occupancy of a dwelling to family. Okay, then we had Mrs. Moore, who was a grandmother. She had a son and a daughter, and she ended up taking care of the son's child, grandchild 1, and the daughter's child, grandchild 2. Okay. Grandchild 1 and grandchild 2 are cousins, as we understand things, right? But the state law defined family such that grandchild 1 and grandchild 2 were not family. So they couldn't live with her, okay? So the state's interest, okay, was to limit the number of people in the dwelling, keep the noise down, and minimize traffic congestion. All of these are legitimate state interests, okay? But the law has to be rationally related to those interests, okay? So the court held this law is irrational. She was actually arrested, okay, and put in jail for a little while things got sorted out, okay? And I say to my students sometimes, can you imagine the bank robber comes up to grandma and says, hey, I robbed a bank. Why are you in here? And she has to say, well, I let grandchild 1 and grandchild live with me, and they were cousins. They weren't siblings. But the court says that's irrational because the son could have had 30 kids and they all would have been family, and that would have been fine. They could all live with her. But 2 cousins, 2 grandchildren who were cousins was beyond, okay, the definition of family. And the court said, you know, this is irrational. So I just thought I'd put that out there. It's kind of fun to think that, you know, a state can pass an irrational law. Okay, so, okay, if I have the situation where laws at a minimum have to be rational, and that's where the Supreme Court analysis started, okay, but I know intuitively, okay, as a reasonable person, I know that some rights are more important than others, and even our framers thought so because that's why they had the Bill of Rights. Okay, then I can't subject both types of rights, really important rights, and not as important rights to the same level of review. That just doesn't make sense. They're not any different in law. So I needed a court, a judge, okay, I needed some kind of analytical framework. And the Supreme Court finally recognized this in 1938. It said, whoa, you know what? We got a problem here, okay? We're trying to look at all these laws as if they just need to be rational, but then that ignores the reality that some are more important than others. So the court says, well, you know what, maybe we should be subjecting these really important rights, those in the Bill of Rights, to strict scrutiny, okay? So that's what happened, right? So that's where I get this, visually, I try to represent this as this hierarchy, right? So the fundamental rights are, I put at the top of the importance scale, if you will, and ordinary rights are at the bottom, and fundamental rights are part of our liberty, okay? So the logic then kicks in. the more important the right, the harder it should be for the government to regulate it. Fundamental rights should be hard to regulate in our democracy, okay? So the court said, hey, those laws have to meet strict scrutiny. They have to be necessary to achieve a compelling state interest. That's a higher burden than rational basis, okay? Because it's a higher burden, I go back to my understanding of democracy. When a law burdens a really important right, like a fundamental right, that's where the individual has the best chance of winning against the political majority that passed the law. Okay, that's important to keep in mind. So laws that regulate fundamental rights have to meet strict scrutiny, necessary, compelling. The corollary to that, of course, is I go back to those ordinary rights. Those ordinary rights should be easy for the state to regulate. In fact, they just have to be rational. Okay, and even though they can pass irrational laws, it's not hard to pass a rational law. Okay, they should be easy to regulate. That's where your majority wins. Okay, so it sort of looks like that. And that dotted line is represented by the word liberty in the 14th Amendment. So if I'm out there practicing law and I'm representing an individual, for example, I want to persuade the court to put the right above the line. So maybe I want to talk about physician-assisted suicide, and I won't use the word suicide, for example. I will say, well, a person should have a right to die with dignity. I want to get it above that line because that's where the individual has the best chance of winning. If I want the law to be held constitutional, I'll try to keep it below the line if I'm representing the state. Okay, so that's just another way of presenting it. You know, some of my students, probably I'm a visual learner, so I try to do both the voice, the audio, and the vision. This is where I just love trying to put these things into graphic representation. I just love doing this, so hope that it'll be fun for you as well to look at it. All right, then I have to say, though, abortion is different. I've got this hierarchy of rights, and then along comes Roe versus Wade, okay, and we have to talk about a woman's right to choose. And the court says, whoa, there's so many competing interests in this decision. The court situates the right above that liberty line. Okay, so it's part of a woman's liberty interest, her right to choose as part of her privacy. Okay, but because the court says, because this is a unique kind of right, okay, and all these competing interests, and people feel differently about abortion. For some people, you know, life begins at conception. For other people, it begins later in the pregnancy and so forth. So the court just recognized all these competing interests, but it put the right above the liberty line, okay, and then lowered the standard of review from strict scrutiny. So it created what we call this intermediate level of review, and laws that regulate abortion or a woman's right to choose cannot impose an undue burden on her choice or place a substantial obstacle in her path. Visually, that's how I represent it. So it's easier to regulate abortion than it is to regulate, let's say, free speech. But it's harder to regulate abortion than, let's say, it is to regulate who gets a driver's license. Okay, so it sort of created this mid-level of review. Okay, and again, I just put this back up here, and at the bottom, in that rational basis realm, that very bottom, ordinary rights, rational basis, I put some of those rights in there, like education is not a fundamental right. So states can decide, well, what are we going to allow critical race education in our schools? That's put to a popular democratic vote. You know, it's like the majority can decide that, right? It's not about the individual. Can you smoke marijuana, recreational marijuana? Well, states can decide. And that's why we get this variation among the states when we're below that line. That's where states have a lot of power. Their police powers, okay, are at play. And that's where the majority is likely to win, okay, unless they pass an irrational law, okay? For the individual to win, we want to get above that ordinary rights line. We want to be part of liberty. Okay, deep breath. Okay, let's focus on people now. Okay, equal protection is the right to be treated equally by the state. And it only makes sense because the government is constantly comparing people, treating people differently. Okay, comes right out of the 14th Amendment. Nor shall any state, again, only the state can violate our equal protection rights. Okay, equality only makes sense if I'm comparing people to each other. Okay, and basically we're asking ourselves, do we treat everyone the same? Or do we treat people differently depending on certain characteristics they have? That's the critical question. So one example that I often use in class is the first grade teacher. Okay, public school teacher, right? State action. I have all these students and I want them all reading at a certain level at the end of the year. I can give them all the very same book, but if one of my students is blind, I may have to spend more money on that student to get a book in Braille so that it's a meaningful book for that student in order to meet my goal of having them all be equal at the end of the year, reading at a certain minimum level. And most people say, well, that makes a lot of sense. Okay, but I'm treating them differently. Okay. So then the challenge becomes, what differences among people matter? So that treating them differently is to treat them equally. Okay. And that's hard to, it's hard to define equality. It's like, if I ask my students to do it, you'd be surprised how many different definitions I get. But then all you have to do is think about separate but equal was how the court defined equality for the longest time. Okay, until really the 1950s in Brown versus Board of Education, when the court said, whoa, that's not equality. A lot of different ways to define equality. But we know intuitively, just like not all rights are the same, not all types of discrimination are the same. Some types of discrimination are more acceptable than other types. Then we just have to figure out, well, what's acceptable and what's not. Well, when the court was first interpreting the Equal Protection Clause, okay, some butchers who were kept out of a monopoly butchers enterprise said, whoa, you're treating us differently, right? And the court said, butchers, this Equal Protection Clause is not about protecting butchers from a monopoly, it's about protecting people from race discrimination. So right out of the gate, so to speak, we knew, okay, that the Equal Protection Clause was about protecting people, the newly freed slaves, from race discrimination. Then we have to say, well, is it ever okay for the government to discriminate? Shouldn't we be suspicious of all discrimination, not just race? And the court says, well, good point. Here's that footnote 4 again, right? Laws that discriminate against discrete and insular minorities should be subject to strict scrutiny. And the court mentions racial and religious minorities. So the court is telling us that discriminating against religious and racial minorities is like not acceptable. Okay, unless, okay, we'll talk about that, unless the government can meet strict scrutiny. But in thinking about whether classifications of people should be subject to strict scrutiny, the court looked at 3 factors. It looked at the immutability of the factor that characterized the group. This is why there's so much discussion about sexual orientation and whether it's something that you're born with. That's why it's important under equal protection. That's why people make it important, right? Because immutability, there's this idea that, well, it's not fair to discriminate against people when they have a characteristic that they can't change. Then we look at the history of discrimination against the group. And then the court looks at the relative political powerlessness of the group. All of these things make sense, because if a group were politically powerful, well, then it wouldn't pass a law that discriminated against itself, presumably, right? So the court looks at all these factors, but it's not at all clear today. In fact, this is one of my favorite final exam questions to ask, how would you order these? it's not at all clear that the court, how the court orders these, what combination works, or even if they matter anymore. Okay, all we have to do is think about affirmative action. Okay, affirmative action is seen as a form of race discrimination, but we know that white people do not have a history of discrimination and they are not politically powerless. So you see, you kind of get an idea. It's like, well, okay, I'm just not clear, but these made sense in the beginning, okay, because in the beginning, religious and racial minorities met all three. And that's why the court said, well, we're suspicious of laws that discriminate against religious and racial minorities. Okay. So racial discrimination is especially unacceptable. But what about other groups? And here again, the court needed this analytical framework. Okay. Racial classifications have to meet strict scrutiny. They have to be necessary to achieve compelling state interest. Okay. And again, the more suspicious we are of the discrimination, the harder it should be for the government, okay, to burden that, to impose that burden on us. Okay, that favors the individual over the state. The less suspicious we are, the easier it should be for the state to win. That favors the state over the individual. Okay, that's where I get my equality hierarchy. Okay, now just the relocation of the Japanese Americans in World War II, Korematsu, I'm sure you're all familiar with that. That was a law that classified on the basis of race and passed strict scrutiny at the time, the protection of national security. Of course, since then, the court has said, oops, right? And Congress, of course, passed reparations, but that was an example. So just because something might be subject to strict scrutiny doesn't mean that it's unconstitutional. If the state can meet the burden of justification, the law will be constitutional. Okay, now agree or disagree. Again, I just have time to describe, but we can certainly talk about this. Okay, some types of discrimination in our society are acceptable. Discrimination on the basis of age, wealth, and disability only have to be rational. And I know that's controversial. Some of these are more controversial than others, but this is the Supreme Court's picture. And this is the picture that it's drawing for us. Wealth is not hard to understand in a capitalist society. We pay different levels of income. We, get different levels of services depending on our income and so forth. But age and disability are a little bit, disability is probably the most controversial. But age, wealth, and disability simply, laws that regulate those simply have to be rational. Okay, so there's my hierarchy with respect to the state. So again, if I'm representing a group of people, a law that classifies a group of people, depending on whether I represent the state or I represent the individual, I know where I need to argue or frame how I need to frame my argument. And then, just like in the rights context, abortion is kind of unique. Lo and behold, gender and sex equality are unique to the court as well. All right, so if you think about the beginning, like when the court was deciding laws that discriminated against women, right? And you think of the late Ruth Bader Ginsburg, right? Justice Ginsburg. Yes, okay, we thought about sex as immutable. I know it's a lot more fluid now. History of discrimination against women, yes. And political powerlessness, relative political powerlessness, I put yes, but of course the court in the earlier cases said, well, they make up 51% of the population, and so they're not politically powerless, which I thought was somewhat disingenuous, but you kind of get the idea. The point is, okay, laws that burden, okay, or classify people on the basis of gender or sex, okay, do not have to meet strict scrutiny. They have to meet intermediate scrutiny. So they have to be substantially related to an important state interest. And the court lowered the standard of review because there are real differences between men and women, citing reproduction and physical strength. And again, these are controversial. We can agree, disagree, but this is the court's picture. Okay, so there's my equality hierarchy, right? We're really suspicious of race discrimination, racial classifications. We're not as suspicious of sex classifications, and we're okay. for the most part, with wealth and age and disability discrimination. Okay, so again, if I can get above that dotted line, I'm into the individual rights, I'm upping the ante for the state, so the individual has a greater chance of winning in a democracy. But if I can't make it above that line, the individual's lost in the political majority. Okay. Okay, so I just want to remind us that rights are rights and people are people, because there's a bigger picture here. There is a symmetry to equal protection and due process, right? Due process has 3 levels of review, and equal protection has the same 3 levels of review for all practical purposes. So if I were to put them on a piece of paper and just fold it over, it looks like they would coincide really nicely. Okay, and that was what was the fear, okay, when the court was deciding whether gay marriage is constitutional, okay, because that's a trap. Okay, due process and equal protection are independently significant. That means that equal protection applies at every level on the rights hierarchy. So here's how I picture that. I hope it doesn't overwhelm you, but it's meant to help. Okay, so if I have my due process hierarchy over on the left, okay, I've got my strict scrutiny, intermediate scrutiny, rational basis. Wherever I am on due process, if there's an equal protection question that comes up, that whole equal protection analytical framework kicks in. Okay, and I'll keep putting this up because it can be a little bit overwhelming when you first look at it. What does this mean? It means that the highest level of review applies because due process and equal protection are independently significant. Okay, so here's the logic to this, and in some ways it seems somewhat counterintuitive, but we just have to reflect on it a little bit, and it's like, oh yeah, okay, that does make sense. The more important the right, the less important equal protection. And the less important the right, the more important equal protection. So I go back to this, okay, and I kind of get it. I think I get it. So I go down to my rational basis box, for example, on due process rights. Education is not a fundamental right. It's in that rational basis box. But if a public school system were to say, oh, kids have to go to separate schools based on race, okay, people might come up with some rational reason for that. Like in prisons, for example, when they segregate prisoners on the basis of race, they'll try to justify it by saying we need to prevent gang violence, okay? But it's a classification based on race, and racial classifications have to meet strict scrutiny, okay? The state, in other words, can't escape its burden, okay, by manipulating equal protection and due process. So that's why I really want people to understand there's no such thing, for example, as gay marriage, because there was a fear that gay marriage would be seen as a right and it would be different from marriage. And then the court could manipulate due process and kind of ignore equal protection. But in that case, actually, it did ignore equal protection, but that's because it said marriage is marriage. And marriage is subject to strict scrutiny because it's a fundamental right. Okay, so it wouldn't matter. Okay, so if it wouldn't matter where sexual orientation fits on the equal protection paradigm, because strict scrutiny is strict scrutiny and you can't get higher than strict scrutiny. But you can't take something like education and just subject all laws to rational basis when strict scrutiny says, whoa, state, you have to justify this. Virginia Military Institute, before you can exclude women, okay, you have to meet intermediate scrutiny. It's a higher level of justification. Okay, take the right to have an abortion, a woman's right to choose, intermediate scrutiny on the rights paradigm, on the rights framework. But if the law were to say, well, only white women can get abortions, the state can't escape the higher burden of justification by relying on due process, because it's about equal protection. It's about who can get an abortion. Abortion is the right, Well, who can get it? And if you're going to say only women of a certain race can get it, that's strict scrutiny. If you're going to say, okay, only women of certain level of wealth can get it, that's not going to enable you to apply rational basis review under equal protection because it's a fundamental right. So you can't escape, you state can't escape your burden of justification by manipulating these paradigms. I know I'm giving you a lot, right? Can I just take a minute to explain the role of Congress in all this because it's relevant to what Kim was talking about last week.
I would, Sharon.
I'm sorry?
I would do it.
Oh, okay, great. Okay, it just take me a few minutes and then we have the big picture. So Section 5 of the 14th Amendment gives Congress the power to enforce the 14th Amendment by appropriate legislation. And of course, lawyers just love these qualifiers, right? So I can't emphasize enough, that's what Congress can enforce. Okay, that is what it can enforce. Right now, sexual orientation on the equal protection paradigm has not been identified as being in rational basis, intermediate scrutiny, or strict scrutiny. So it's questionable, okay, if it's not there, does Congress have the power to protect people on the basis of sexual orientation? Okay, let me keep going here, okay? Enforce means enforce. Enforce does not mean create. The Supreme Court tells us what the 14th Amendment means, and Congress can interpret the court's can enforce the court's interpretation. Okay, that's what Congress can enforce with respect to due process. Okay, and that's what it can enforce with respect to equal protection. Congress can enforce that picture. Okay, it can enforce that. Go back to the peyote case that Ken was talking about last week. State says it's a crime to smoke peyote. Neutral laws of general applicability are subject to rational basis review. It is rationally related to the state's interest in protecting the health, safety, and general welfare of its citizens to criminalize the use of peyote. That's what made that constitutional. And remember, Ken described it so well last week. Well, everybody kind of went a little bit crazy. You know, I remember President Reagan saying, oh, that's outrageous, you know. So Congress challenges the Supreme Court and says, whoa, we're going to fix this. And they passed the Religious Freedom Restoration Act and says, we're going to subject these laws to strict scrutiny when they impose a burden on free exercise of religion. Okay, do you understand? The Congress, in other words, is saying, whoa, the state has to meet strict scrutiny. The law has to be more than rational. Okay, and Congress was using its Section 5 power to do that. And the court yells back at Congress, basically, you don't have the power to do that up there on the Hill. You can only enforce, you cannot create rights. So that level of scrutiny is part of the right. When the court said neutral laws of general applicability are subject to rational basis review, that's what Congress can enforce. Congress can't make it a stronger right than what the court says it is. That's what made RFRA under Section 5 of the 14th Amendment unconstitutional. Congress doesn't have the power to create rights. Okay. So we go back to that, right? Fundamental rights are hardest for the state to regulate. Individual has the best chance of winning. Ordinary rights, presumed constitutional, they just have to be rational. This is why there's an interest in the question whether the court will overrule Smith. Because remember, Smith left it down there in that rational basis realm. Okay, and the court can put it back up in strict scrutiny. Congress couldn't, but the court could do that. And then it makes it harder, okay, it makes it easier for people to claim exemptions from these neutral laws of general applicability. And that's kind of what's at stake in some of these. I think that this case eventually will get to the court, right? It's sooner or later. Okay, I know you probably think, thank goodness that's over with. But I put my email up here because I sincerely mean this. I love this stuff. I love talking about it. I would love to engage one-on-one with any of you if you want to write. Please feel free to do that. And thank you.
Okay, thank
Do
you.
we have questions for Sharon? If you do, raise your hand or do the use the raise your hand button on Zoom.
Okay, Shirley, go ahead, unmute.
Hi, I just have a question, probably doesn't make sense, but
It does.
where does a fetus come in to have any rights?
I'm sorry, where does?
A fetus.
Oh, okay. Well, you know, this goes back to what I was saying. The court, when it was first looking at this, it simply decided, okay, how to balance these competing interests. And some people will say that life begins at conception. And then there are analytical frameworks that apply if that becomes the law. Then that life will be protected from the moment of conception. Right? So yes, but that isn't how the court has interpreted it so far. So I get all the competing interests. Okay. And it could be that the court overrules it and drops the right to choose down to the rational basis realm, right? To where states, then the political majority in states, some states are going to allow it and some states are not. And some states will say life begins at conception, and we know that some states will not. Okay, that's where that state has the greatest, that's where the state controls. Right? It's only because of the court's interpretation, and I totally appreciate the question, because reasonable people can disagree on these things. And I simply was trying to describe the court's mural, because that painting up on the wall, okay, is what Congress can enforce. But the joy in all this, especially when we're talking about intellectual exchanges and so forth, is that we can disagree and we can see things differently. And we can, it's sort of like a chessboard, right? We can say, well, what happens if I move that piece here or that piece there? And I might be more comfortable moving them around. So I totally get what you're saying, but that isn't so far how the court has balanced things. It may become,
Thank you. It helps to get some rational approach.
Mary Gerson, go ahead.
Well, your command of this subject is awesome.
well, thank you.
And I do feel overwhelmed. And I'm wondering if we could have a copy to download of your slides, because a lot of the print was awfully small to see.
Oh, was it? Okay, yeah. And I would love feedback too.
So I wonder if Julie, could it be possibly sent out to you and we could download and print?
I can send them to you.
Whoever could, that would be, don't other people agree? I would love to see those charts better.
And you know, it's sort of like you know, connect the dots or whatever, but if you had it before you, you could actually fill in those blanks. I didn't know how to do that graphically, but you can put race and sex and all the different things on there, and it just becomes it becomes.
No. Well, I'm one who has a visual memory too. I like to see things. It can be in print, it doesn't have to be images. It can be,
Yeah,
but it helps me a lot if I can get it in diagram form.
great. Thank you for saying that, because sometimes when I'm drawing these things, I wonder if the students think it's kind of silly, but over the years, I've read evaluations and they say it's invaluable. So I keep doing it.
Yeah.
For
you
now,
can-
anyway, for our Okamic residents, come on down to the Oak Room. It's nice and big on the big screen.
I know, that's why, Ellen, that's why I really want to come down. I'm known as the draw law prof at the school.
We're
I
getting
draw.
closer, I think.
If I can conceptualize it, I'll draw it for you.
All right, Rick Gold, go ahead.
Thank you for an amazing, superb analytical instrument that allows us to think through these issues. I'm part of a group of organizations that are engaging with the Equal Employment Opportunity Commission to help them to understand that caste discrimination falls under the racial discrimination that they need to enforce. How would you look at that in terms of your matrix dealing with due process and equal protection?
Wow, that is, that's such a challenging question. Very, very intriguing. Because when you think of it, the first thing that came to my mind when you used the word caste, of course, was India, right? And then you think it's about more than wealth, because wealth discrimination in a capitalist society is where it's at, right? Because there's that sense that everybody can pull themselves up by the bootstrap, but we know that's not true. And we also know, okay, that there's a strong correlation between economics and race in this country and gender. So I'm assuming that's what you're kind of getting at. But of course, we would never call our system a caste system.
Yeah, it particularly deals with South Asians who are in the country. There are like almost 5 million of them at this point.
Yeah. I really want to think that one through, because I mean, the fact that because there's a strong correlation, the court isn't really recognizing causation, if you will, right? So there has to be almost intent. You can't have what's in law called a disparate impact. Okay, and those of you who've studied law, you'll know what I'm talking about, right? So you can't, a disparate impact won't turn something into a racial classification unless there's an intent to discriminate on the basis of race. And that's going to be your biggest hurdle, because these are otherwise are just laws that classify presumably on the basis of wealth. Okay, and it just happenstance, so to speak, that it affects disproportionately, okay, people of color. Right? So that's the biggest hurdle, because disparate impact isn't really recognized as a racial classification. And I can't get to that higher level of scrutiny. I'm just down in the rational basis realm. So, but yeah, I think that's fascinating. And I totally agree with you. I mean, when you think about Brown versus Board of Education, you might or might not know this, okay? But when we had the separate but equal doctrine, right? The court presumed, and we know this was not true, the Black and white schools were woefully unequal in terms of resources and so forth, right? But the court said, let's assume that they're equal to get to the heart of the matter. And the heart of the matter was the racial discrimination, okay? And then, 10, 20 years later, the court gets the same case in a way out of Texas, okay, where the Mexican-American students, okay, they're segregated not because by law, no, they just because of neighborhoods, right, because of wealth, okay. So the Mexican-American students are going to school over here, and the white students are going to school over here in the suburbs. They have a lot more money, okay, in the wealthy suburbs per pupil than the Mexican-American students, right? And the court said, but it's not racial discrimination. Nobody's making everybody go to these schools according to race. It's wealth discrimination. And that's one of the worst mistakes, okay? So in Brown, we assumed wealth equality to get to the crux of it. And then when we get to Rodriguez, okay, versus San Antonio in Texas, right? We ignore race to focus on wealth, and then wealth is just rational. Does that make any sense? I mean, I can talk more to you about it. I'd be really interested to learn more. It's a problem. It's a real problem.
Yeah, Rick, it's a problem that's faced in almost all these types of cases.
Yes, exactly.
And unfortunately, the agencies are not as attuned to the concepts that that Sharon has discussed today, and they pretty much do what they want, and that's why these cases end up in court. And that's why there's such a fight with the courts, especially if you've been, like I was, a trial and appellate attorney doing a lot of these constitutional law cases, why there's such a fight for a compelling state interest in how they do their regulations.
Right.
And we've shifted, the courts have shifted generally to the right on compelling state interest.
Right.
And they give the courts a lot of leeway in being able to defend why there is a compelling state interest on how they do their regulations.
Right.
And that's why Sharon is right. It's very hard to win those cases. And if you're representing individuals or groups of individuals or people in class actions, and why you need to get above the line and into a liberty interest.
Great. Thank you so much.
Peter, hang in there with me. You're next. I'm going to go to Donna. Go ahead.
Hi. Are voting rights seen as fundamental or ordinary by the court?
Fundamental. And they're really governed by the 15th Amendment. And I'm not a 15th Amendment expert, but yes, the right to vote is protected, part of the 14th Amendment liberty interest as well. It is definitely fundamental. But you understood what I meant when I said, we all understand what the black vote is or the white vote, right? But there's no such thing, right? And so I just get really, I just am afraid when the court starts collapsing due process and equal protection, that it doesn't have good intentions, if you will. And I hope I'm not insulting anyone here, but it's sort of like, why would you need to do that when you have these separate analytical frameworks that you yourself have set up? So play by the rules you laid down, right?
Thank you.
I don't know if that helps, but.
Oh, no, that was very clarifying. Thank you.
All right, Peter Hyatt, go ahead.
What is the basis that the court uses to decide what is the state interest? In the case of abortion, there is no law that says that a fetus is a citizen, but there is a law that says that you're not a citizen until you're born. But somehow they've decided that there is a state interest in protecting somebody that doesn't exist, and I'm wondering what is their rationale for getting there.
Well, it really just depends on the court's interpretation of, I mean, the court itself, when it first decided Roe, it said it's not our job to say when life begins. We'll leave that to the religious people, right? I mean, it says that, right? But in essence, it decided that life doesn't begin at conception, right? So
but the law doesn't say that, though.
No, it doesn't. The state has an interest in protecting the health, safety, and general welfare of its citizens, and how you define the unborn. Right now, the court has told us, okay, how those interests are in competition with each other and how to order them. I think that's all going to change. And if it drops below the line, okay, then states are going to have a lot more leeway because they have a lot of police power. That's what that is. And some states will allow abortions and some will not. And some will have some in between. You can get it up to this amount of time, but you can't get it after that. They'll have.
So you're saying really there isn't a legal rationale for this, it's just an emotional rationale.
Well, it's legal in the sense of who decides. That's what we're talking about, who the decision maker is. How the decision maker makes the decision is what you're asking, but that isn't what the law is concerned with. The law is concerned with who's going to decide, not how they decide. But is it going to be the state that decides, or is it going to be the court saying that the woman can decide? Because if a woman really thinks that life begins at conception, even though she might have the choice, that's what it is, a choice, and she probably won't get an abortion because of her personal belief, right? So she will be the decision maker. So think about conjoined twins, for example. Okay, so even though we have two live individuals, okay, who are conjoined twins, right, who are connected, we're not in the abortion context. We have birth, we have people, right? The question really is, okay, about who's going to decide whether they stay together or whether they get separated. Okay, is that going to be something that a state gets together and the majority says, well, conjoined twins have to stay together and then they just live their natural life? Or a state could get together and say, well, we're going to let parents decide, or we're going to let doctors decide, or we're going to say this is a matter of a family's liberty interest. And most parents are very loving parents. And faced with this just unimaginable, hard decision, we could let it reside with the parents. And there is probably no right or wrong to some parents will separate them, even knowing one will die. Okay.
Well, my question is, the court, there is no law that says I can't have my appendix out. And there also is no law that says a fetus is a person.
Right.
But somehow they've decided there is a difference between an appendix and a person. And a fetus. And I see no basis for law to make that decision.
Right. Well, you notice the law, a lot of states, maybe all of them, I don't know, I haven't looked this up, but it's not lawful to commit suicide. I mean, you can't even take your own life, right? Without, I mean, it's sort of ridiculous, isn't it? But in some ways, right? But suicide is not condoned. That's why we don't allow physician-assisted suicide, even though really competent adults are deciding, look, I've had enough of this treatment, I'm ready to go. But we don't.
In Oregon, it is legal.
Well, states can always give you more than is constitutionally required. This is a wonderful point. Thank you. States can always give you more. They can't give you less. They can't give you less than is constitutionally required, but they can give you more. So just because, for example, here's a good example, maybe this will make it clear when I say that. The death penalty is constitutional. It's not a violation of the 8th Amendment, cruel and unusual punishment incorporated to apply to the states through the 14th Amendment. States don't have to put you to death for certain crimes, okay, but they can put you to death and it won't be a violation of your constitutional right. But that's up to, states can give you more, but they can't give you less. Does that make sense? So
yeah, but I don't see it as it's an analogy.
Well, what makes some, it's the political, I often ask my students, who is the state, right? Which is somewhat of a rhetorical question because I don't even know who the state is. But for some purposes, the state is the political majority. So if the political majority says life begins at conception for state X, that's going to be what it is. And it's going to be the political majority who's making that decision. And whatever it's based on, that's what it's based on. It's probably going to be a lot of different reasons I will vote for this law. It might be my religious conviction. It might be my sense of morality. It might be I'm voting this way because Uncle Joe told me to vote this way, whatever it is, right? But I don't know what that is, but I know, okay, that for me, it's about who's making the decision and what are the consequences of putting the decision-making in the hands of one institution or one person over another. Does that help at all? Because people have different conceptions of this. Abortion is very complicated. It's very, very complicated. But when I talk about conjoined twins, I want to say that regardless of how we might say when life begins, and people have different understandings of that, it doesn't obviate some difficult questions. It might not obviate some difficult questions, like what happens if a woman is raped? That adds another layer of complexity to it, even though, okay, we might accept that life begins at conception, or what happens in the case of incest or incestual rape. I mean, it's a complicated issue. And so the question really is, who gets to decide? At least for me, the question is, who gets to decide?
Sharon, do you see the question in chat goes with what you just said? How is it rational or constitutional that Texas include incest or rape when both are illegal?
They're just competing interests. So if the voters of Texas, okay, let's say the state overrules Casey, right? And says, okay, suppose the court were to say if the court were to say life begins at conception, right? Then I don't know where I went. Did I just go away?
No, you're
Oh,
here.
you're here.
Oh, okay. All of a sudden I don't see anybody. Okay.
We see you.
You see me? Okay, well, that's what matters. I don't see you though. Okay, oh, here you are. There you are. Okay, so the light could, the court could drop the right below the line, and then states are going to be deciding, right? But if the court were to say life begins at conception, okay, then states would be in a position where they would, I don't know what kind of laws they would pass, but abortion wouldn't be legal. But that doesn't mean that there are always concepts of justifiable, it sounds so awful, justifiable homicide, right? I mean, not all homicide puts you in jail, but some types of homicide are acceptable. So like if a woman's life was in jeopardy and it was her life or the child's life now, because we're calling it a person, right? If she were to choose her life over the child's life, even though abortion would be illegal, it probably would be justifiable for her to have an abortion, right? I can't even remember who asked this question. I don't even remember what the question
was
was.
in chat.
You disappeared and here you're back again. It's just complicated. What I want you all to take away from this is that power balance and how the power balance shifts. And when we're in the states' rights realm, which is a strong movement today, it's a strong movement to get a lot of those rights below the line. Except, I mean, it's a double-edged sword. We have to be very, very mindful. It's a double-edged sword, okay? Because when the court put the Second Amendment right to bear arms above the line, because for the longest time it was below the line, right? You didn't have an individual right to bear arms until very recently. It went above the line, okay? So that protects the individual. That's why we have all these laws, okay, where individuals are saying, well, I have a right to carry this gun. I have a right to carry this gun. It's not up to the political majority just saying you can't carry a gun. You can't have a gun in your house. You can't carry a gun outside. That's the political majority speaking. But once you elevate that right above the line, then the individual has the best chance of winning. And sometimes those rights, sometimes we can agree with what's happening and sometimes we'll disagree with it. And and the great part about law is that I know we have concepts like stare decisis and precedent and so forth, but the law is fluid, it changes. Okay, and I think I talked to you about this last time we were together. It's sort of like that heart monitor, right? In a democracy, you have to be willing to win some and lose some. Sometimes you're on the upswing and you're winning, and sometimes you're not. But law can't mean the same thing all the time forever, okay? Because then we flatline and we'll have constant losers. And whenever you have constant losers, you get revolution. That makes sense? So it changes okay, but it's not always going to change the way I want it to change. And don't misunderstand what I'm saying. Some of the changes that I see happening, I think really threaten our democracy. I think if I were going back in to teach, if things keep going this way, I'm afraid I would be asked to teach history instead of constitutional law, because I feel like the Constitution is threatened in a lot of different ways right now. But that has less to do with 14th Amendment and more to do with the supremacy of federal law and separation of powers and things like that, which is maybe a different lesson for a different day, different time.
Well, I appreciate your session today. And if anyone wants to be in touch with Professor Rush, I'd be happy to. If you want to contact me, I can pass along her email.
Excellent.
Ellen, any final thoughts or introduction?
No, Sharon, I thought your presentation was excellent as usual, and your PowerPoint is very helpful. And to the extent you can share it with us, we would appreciate it.
I'll send it to Judy.
Could I add that I really would love to see her do a course on the ways that she thinks democracy is challenged?
Well, Shirley, we're going to do a course eventually, the two of us, but we're waiting till we can do this live. So we can have all the ILR members, not just the OCAMIC members, come back to the Oak Room and be participants in the course.
Wonderful. Looking forward.
It's going to take some time to put that together, but we first need to know when we're going to go back to live presentations. But we have that, we started talking about this almost a year ago. So it's in the brain works, as we say. But the only thing I want to add is I know these concepts are very difficult for non-lawyers, but at least when you go to vote, you should think through some of these issues because you'll be better voters and more intelligent voters if you do. And also, although we haven't covered it today, this is why some state laws end up on the ballot for referendum. Because there is a disagreement whether or not the state carefully looked at a compelling state interest and whether the defense of that compelling state interest really was properly decided, I will say, by the court. And that's why we have referendums, so that people can demonstrate whether or not they agree with a law that has been passed by the state. And if they win on the referendum, then the law has to be changed, or it has to be, eviscerated in some respect. But we can cover that in another session. But I just wanted to show you there are downstream effects of everything that Sharon has talked about today. So if there are no other questions.
Thank you again. I really, really enjoyed it. And it's such an honor to be included in this group. And holler at me.
Thank you so much, Sharon.
Okay.
Stay well. We'll see you next week.
Stay safe. Okay.